I'd say the most common contract defect in employment law has to do with illegal terms. And you might be thinking, why in the world would a lawyer draft a contract with an illegal term? But it has to do with the way that laws work in this country, where we are always keeping up with how the courts are interpreting termination provisions. And then that causes a whole flurry of contract amendments. And then that's when you get an employment, your employer will give you a new contract with a new termination provision in exchange for a signing bonus. So we're always one step behind. Probably the biggest case that happened in recent years was during the pandemic. The Court of Appeal was dealing with a without cause termination of an employee. So that's a termination where the employee didn't do anything bad. They're just let go. But for some reason, they were fixated on the with cause termination provision in the contract, which only applies when you do something really bad, you get let go, and you don't get any severance. And the court pointed out that that contract, that clause for just cause termination, was talking about a broader concept of just cause, which under the common law, judge-made law, case law, covers a whole whack of bad conduct. But the Employment Standards Act, which is the legislation that sets minimum entitlements on termination, has a much narrower definition for just cause. And the Court of Appeal was saying, well, look, you're saying that even if the employee does bad things beyond that small definition, they still don't get severance, and that is illegal. And so even though this particular employee wasn't even let go for just cause, the court was so hung up on that they said, no, it knocks out your entire termination provision, and that employee is now entitled to common law notice.